6 months of defiance. The December 17th hearing did not emerge out of nowhere. It was the culmination of 6 months of escalating judicial frustration, marked by repeated court orders, rejected privilege claims, and what Judge Burman would later describe as manufactured delay. At the heart of the dispute were FBI records tied to the Jeffrey Epstein criminal network, including documents referencing social and financial ties between Epstein and Donald Trump, witness statements placing Trump at Epstein-owned properties, internal FBI communications discussing political pressure to halt or narrow investigations, recommendations by FBI field agents to pursue criminal inquiries that were later overruled. Congress had subpoenaed the documents. FOIA requests demanded their release. Federal courts reviewed the claims of privilege and rejected them, not once, not twice, but 3 separate times, including rulings by the D.C. Circuit Court of Appeals. Yet despite those rulings, Patel refused to comply. Instead, the FBI under his leadership continued to assert attorney-client privilege, executive privilege, national security exemptions, ongoing investigation, confidentiality. Each claim was systematically dismantled by the courts. The documents were ruled not classified, not privileged, not exempt, not protected under executive authority. Still, they were not released. December 17, 2025, inside the courtroom. On the morning of December 17, 2025, the Federal District Courtroom in Washington, D.C. was packed. Reporters filled the gallery. Legal analysts sat poised to interpret every word. Congressional staffers whispered nervously. Everyone understood something unusual was about to happen. Judge Richard Burman entered the courtroom without ceremony. Known for his measured demeanor and strict adherence to procedure, Burman was not a judge prone to theatrics. PL4 separate orders directing you to produce documents subpoenaed by Congress and requested under FOIA concerning FBI investigations into Jeffrey Epstein's criminal network. He paused. You have defied every one of them. The judge then asked the question that would determine Patel's fate. Do you intend to comply with this court's orders? Patel's attorney stood to respond. Your Honor, the FBI maintains... Sit down, Judge Burman snapped. I did not ask you. I asked Director Patel. That moment marked a turning point. The protective buffer of legal counsel was removed. The responsibility now rested squarely on Patel himself. The refusal. Patel chose his words carefully. Your Honor, the FBI has serious concerns that releasing these materials could endanger national security and compromise investigative methods. Judge Burman cut him off. That is not an answer. Yes or no? Patel hesitated. We believe further review is necessary. Stop. The judge's tone hardened. This court has examined your claims in full. 3 federal courts have rejected them. The documents are not classified. The Director of National Intelligence has confirmed that executive privilege does not apply. The Supreme Court resolved that in United States versus Nixon, the implication was unmistakable. Continued refusal was no longer a legal disagreement. It was contempt. Contempt of court. The nuclear option. Judge Burman leaned forward. When I ask whether you will comply, what I am really asking is whether you are deliberately choosing to defy the constitutional authority of the federal judiciary. The courtroom fell silent. That choice constitutes contempt of court, the judge continued. And contempt has immediate consequences. Then came the ultimatum. Director Patel, you will produce every court-ordered document fully and without redaction by December 20th at 5:01 p.m. He paused. If you do not, I will issue a warrant for your immediate arrest. Gasps echoed across the room. I absolutely would, Patel's attorney objected. Your Honor, surely the court wouldn't. Oh, I absolutely would, Judge Burman replied. His voice was calm, unemotional, final. On December 20th at 5:01 p.m., federal marshals will take Director Patel into custody. He will remain detained until he purges his contempt by complying with this court's orders. There would be no additional hearing, no delay, no political negotiation, just jail until compliance. Why this case was different. Federal judges rarely threaten immediate arrest for contempt. When they do, History shows they almost always follow through. But this case was unprecedented. Never before had a sitting FBI director faced imminent incarceration for defying judicial authority. The stakes extended far beyond Patel himself. If the FBI director could ignore court orders without consequence, the rule of law itself would be undermined. The judiciary would be rendered powerless against executive obstruction. According to sources familiar with the subpoenas, the files included records of Trump's social interactions with Epstein, witness testimony placing Trump at Epstein properties, flight logs, internal FBI discussions referencing political pressure from Trump appointees, suppressed recommendations to open criminal investigations. One day before Patel's deadline, December 19th, the court had already ordered the release of additional Epstein files, including victim testimony. That timing was critical. Once partial disclosures became public, continued withholding would become indefensible. Selective disclosure and political obstruction. Judge Burman noted something even more damning. While Patel claimed he could not release Epstein-related files due to privilege, he had authorized releases targeting Trump's political opponents. That selective use of privilege, the judge said, strongly suggests political obstruction rather than good faith legal judgment. In other words, the court believed Patel was not protecting the law, but protecting a person. The legal foundation for arrest. Judge Burman cited Title 18, U.S. Code, Section 401, which authorizes federal courts to punish contempt through fines or imprisonment. He also clarified a critical point. Presidential pardons do not apply to civil contempt. Executive privilege cannot override court orders. Judicial authority is constitutionally supreme in this context. Patel could not be saved by political intervention. Professional consequences, disbarment. The judge then introduced another devastating consequence. This court is prepared to refer this matter to state bar associations for possible disbarment proceedings. Patel held active law licenses. Willful defiance of court orders could permanently end his legal career. Compliance or incarceration, release or ruin. The countdown begins. By December 18th, sources indicated Patel still had no plan to comply. Some believed Trump would intervene. Others speculated about political pressure. Judge Burman had already closed those doors. With 48 hours remaining, the nation watched as a constitutional clock ticked toward a historic moment. Either the Epstein documents would be released, potentially exposing Trump, or the FBI director would be jailed, affirming judicial supremacy. There was no third option. Conclusion: a defining moment for the rule of law. This case was never just about documents. It was about whether the most powerful law enforcement official in America was subject to the law himself. Judge Burman made his position clear. The law applies to everyone, without exception. And at 5:01 p.m. on December 20th, the United States would learn whether its institutions still had the courage to enforce that principle.